afternoon. When I was invited to this event, I accepted immediately, perhaps because my English is not very well. Then I thought I was invited to a lunch, but I was actually invited to a lounge with A. So we are going to provide food, intellectual food, rather than physical food. But I think that the book is really good, and of course you can say I'm not objective because I'm one of the contributors, but I try to support this statement that this is a really good contribution to the literature in the area of investment policy, and it provides very good guidance for policymakers. So I try to make an overview of the book, which contains the first chapter by Martin Correa. He has summarized to a great extent the content of his chapter. Essentially, in the first chapter, you will find what the main problems with bilateral investment treaties and other investment treaties are. So all the shortcomings that you can find in terms of the standards to judge whether investor rights have been violated or not. A major problem, as you know, is the ambiguity of the fair and equitable treatment that is one of the main provisions in these agreements that is interpreted in a very broad manner by arbitration tribunals, leading, as it was mentioned, to very high compensation awards. So this is a very interesting chapter. It is presented in a manner which is understandable to a non-specialist in this field, and it really shows the major problems that the system faces. For instance, one observation that Martin makes in this chapter is that surprisingly 15 arbitrators have been sitting in 55% of the cases. And these arbitrators often are also advisors to the companies which also are parties to this litigation, or they may also be members of the board of some of the companies that are parties to this litigation. So the system it does not provide sufficient neutrality, and it leads to the kind of situation that were just described. The second chapter by Yilmaz Akgüz, it's a very interesting one, although there is quite a lot of literature on foreign direct investment, and it was mentioned by Martin. There are some myths about foreign direct investment. Essentially that they bring more capital into our countries, more technology, and they are pro-development oriented necessarily. And this chapter shows that this is not the case, that there are many myths in relation to foreign direct investment, including in terms of what the advantages may be for the host country. I recall, for instance, one instance in my own country where a foreign car manufacturer was found to have losses for years. So this company had losses every year, and for years there was a situation. So the authorities asked themselves, how is it possible for this company to survive? And then the reply was found. This company was paying royalties on all the sales produced by the companies, and therefore the amount of money that they were transferring to the parent company were huge. And of course the company were losing money every year, but this was much more than any profit that could be actually transferred by the company. So there are many ways in which companies can act, foreign direct investors can actually lead to situations where the benefits that our countries are expecting are not actually realized. This is linked to chapter 4 that was produced by Kinda and our colleague Manuel Montes, that deals with performance requirements. So Martin already mentioned this very important policy tool. And this chapter explores the extent to which these investment agreements prohibit the use of performance requirements, which are essential industrial policy tools. So this is one of the main negative implications of investment agreements. The fact that when an investment is made, the government cannot impose certain minimal conditions in order to ensure that the investment has positive impacts in terms of development. So this is forbidden, and there is an annex in this chapter that shows the type of provisions that are included in these agreements, indicating that the government regulatory power is excluded, and therefore you need to accept whatever the investor wants to do in your country. Whether this creates sufficient jobs or not, transfer of technology takes place or not, it is not something that may be intervened by the national authorities. There is another chapter, I wouldn't say this is the best one because it was written by myself, but this is the worst perhaps. And this illustrates very well the very broad definition of investment that is contained in some of these agreements. Most of these agreements define investment on the basis of an asset concept, or any asset is an investment. Any tangible or intangible asset is an investment. So this means that any credit, money in the bank, even a trademark or a patent is considered an asset. And this may give rights to investor rights, even if the patent or trademark is not really associated to a real investment in terms of creation of production capacity and technology transfer and so on and so forth. So this chapter examines one case which is still pending, a case where a pharmaceutical company, Eli Lilly, is challenging a decision by the Federal Court of Canada that revoked 2 patents because these patents are not compliant with one of the requirements for patentability, the so-called utility requirement. And then the company is arguing that the Federal Court of Canada, the Federal Appeal Court of Canada, has no right to decide what is the national law and to consider that these patents were granted in a wrong manner. And therefore, they are requesting a $500 million compensation because they consider that the rules have been changed, and therefore this is a violation of this famous standard of fair and equitable treatment. Of course, if this case will be won by the company, this will mean that the states will not be able even to change, never to change the policies. So this, because the argument by Eli Lilly is that when they made investment, the utility requirement and the patent was interpreted in a different manner. So if this were the case, the implication would be that the governments and national policies may never change, and if they change, there may be a risk of getting into this compensation situation with foreign investors. Then there is a chapter on the very, very crucial issue of dispute settlement. As it was mentioned, is one of the worst components of this international investment regime. The fact that arbitrators who are not subject to any national law, who are selected, as I mentioned, from law professional, investors professional, in fact, people that now is professional in just doing these investment cases with very, very high fees. And there is a chapter by Natalie Bernasconi, who is a very well-known expert in this field, where she argues that we need to think out of the box. We need to change the system. So this is unsustainable. And there is already strong evidence that shows that the decisions are biased, the decisions are pro-investors, there is no balance with the public interest, this regulatory power of the state is not preserved, and therefore there are some suggestions that would be useful for you to look at in this chapter, how to address this issue of dispute settlement. So the last chapter in this first part of the book is about gender and these investment agreements. It's a very interesting chapter. I really recommend it to read, because it shows how women are discriminated in many cases by foreign direct investors, and how these treaties do not actually protect and get to a situation where there is gender balance in relation to investment. And the second part of the book, and I will just finish, Vice, you don't be nervous and talking too long, is I think is a unique part of the book, because it really tells the experiences of 5 countries. And this is extremely important. This is, I think, the first time where a book compiles this information and very good analysis on the cases of South Africa, and we have the contributor here with us, the case of Ecuador, the case of India, and the case of Argentina and Indonesia. Of course, all these cases are not the same, but it shows what kind of measures countries like this are taking in order to address this problem. So some of these measures, in some cases, for instance, is to withdraw from the ICSID Convention, as the case of Ecuador, to terminate this investment agreement. So that's it. Even if there is a survival clause, the decision is to terminate the system. In other cases, not to renew the agreements, because in general there is a renewal clause. In other cases, also in Ecuador, there are some very innovative approaches to set up a commission, in order to audit the investment agreements. There has been also a proposal to set up an arbitration system alternative to the exit system, and also to develop a project to have an observatory in order to look at how companies act in this area. I will not, of course, mention the South African case because we have the privilege of having the ambassador here. The Indian case is also very interesting. It shows how, and it was mentioned, decisions by the Supreme Court of India have been overruled by a small group of arbitrators who have just considered that it was wrong. So they are just dismissing the national law and the judgment of the highest judicial authority in the country. There is also the experience of Indonesia and how they are dealing with the problems created by the investment agreements. And finally, the case of my own country, Argentina, which is perhaps the country who has received the highest number of complaints under investment agreements. As you can see in this chapter, the total amount of compensations requested by the complaining parties amounted to $80 billion, 13% of the Argentine GDP. So the government so far has been able to avoid paying this amount of money. They have lost many cases, they have won other cases, many are still pending. So, but this is a very, very important fight. It's a survival fight for Argentina. You can imagine if these awards were given, so there would be a complete crisis for the country. And this is just one example of the negative implications that these agreements may have. So just final comment of this book, as I said, of course I may not be objective because I'm one of the authors and at least 3 of the authors, contributors are also here. But I think this is really a very good piece. It's a very competitive book. It's a very good contribution to the literature in this area. So I hope that although there is no physical food, this is really very good intellectual food. I hope you can read and enjoy and get benefit from the policy recommendation contained in the book.